It's my pleasure to introduce Julia Talbot-Jones. So Julia is a senior lecturer in the School of Government at Herenga Waka, Victoria University of Wellington, New Zealand. She has an interest in social and structures, and including institutions, can help solve domestic and global environmental and natural resource challenges. Her research aims to understand how society can better design institutions to the benefit of our environment, the economy, and our communities. Her works essentially establish bridges between economics, ecology, natural resources, and management. So thank you, Julia. So usual rules of engagement, we are going to listen to Julia for about half an hour, I would say. So only clarification questions, and then we have time for Q&As, okay?
Right.
Awesome, thanks, Julia.
Okay, well, thank you for the introduction. It's a real pleasure to be here today. I want to acknowledge the workshop and particularly Scott here for inviting me here. I'm a visiting scholar and have been here through March and just a few more weeks in April. I also want to acknowledge Dan Cole, who's been my sponsor, and some familiar faces who I have talked to and hope to spend more time with over my remainder of my time here. So what I'm presenting on today is very much an emerging project. So I've been a little bit uncertain of even how to talk about what we're doing today because it's so preliminary in its thinking. But the idea behind it is we have this new idea of rights of nature giving legal rights to natural features emerging in the literature, but we don't know huge amounts about it. We also have these emerging challenges around fresh water. There's a lot of crossover between what's been proposed for rights of nature and fresh water, a lot of application in that area. And so we're thinking about some of the institutional aspects of integrating and combining freshwater governance and rights of nature. And it's a good collaboration between Dan Cole here at Indiana and also Dustin Garrick at the University of Waterloo, who I understand is going to be a visiting scholar here for the year. So hopefully we can meet them in person. And I should acknowledge that this piece of research is funded by the Royal Society of New Zealand on one of their Northern grants. And so today is a bit of an outline. I'm going to spend more time talking about the motivation and the problem definition, going to be in some time outlining our early research questions and what the tentative answers could be. But the most important part of today's discussion, I think, is emphasizing what seems to be an increasing number of emerging questions that are popping out for Dustin, Dan, and I. And it would be great to get your thoughts on them, to reflect on what we've said today or what I'm presenting today and see what jumps out from your disciplinary perspectives that could contribute to the collaboration. And so why do we care about fresh water? Well, fresh water is under increasing pressure globally. Today, more than 2 billion of the world's population lacks access to sufficient levels of clean drinking water, and more than 4 billion people face water scarcity for at least 1 month a year. And so we are not on track to reach SDG 6, which is ensuring clean water and sanitation for all. What we understand is that as scarcity increases, social, economic, and environmental interests often clash. And in those circumstances, it is the public good elements of water, those parts that are left in stream, that are non-excludable and non-rival, that often end up underprovided. So the emphasis goes on extracting water for industrial purposes or for drinking water, and leaving it in the system for the environment often becomes second or third objectives. From an Ostrom school or new institutional way of thinking, the solution to this public good problem is to create social institutions. And most people here would be familiar with the arguments around whether it should be left to the state, whether it should be left to the markets, or whether there's alternative arrangements that can deliver the public good. And when it comes talking about that public good element of water, which is again the in-stream flows or environmental flows, things that remain in the system, there's been a clear evolution in the way that we've thought about management. So over the last 50 years, we've seen a shift from what, as our discussions have evolved, we've thought about as evolving from a monocentric system, where there's been a growing recognition of environmental flows and the importance of them in the 1970s. That's translated into a series of administrative rules, such as imposing in-stream flows and trying to change behaviour. That way, through the 1990s, emphasis shifted towards markets and using price mechanisms. So the argument was that the state wasn't addressing things in the way that we should expect for environmental protection. Maybe markets can do better. 2000 emphasis started opening up into thinking about how we can build community into that. And that obviously correlates with Eleanor Ostrom's 1990s governing of the commons, thinking differently about how we can design these institutional arrangements. And through the 2010s and onwards, we've seen growing institutional diversity in how we protect these environmental flows. The problem is we keep coming up against these issues around public good provision. There is clearly no panacea. We don't know what the solution can be to change people's behaviour efficiently and effectively so that we see adequate provision of the public good. And I was wanting to show you a short video, but we couldn't quite work out the screen sharing thing. But 10 days ago in the Murray-Darling Basin, we saw another massive fish kill. And so millions and millions of fish have died in the Baka, and which is the traditional name for the Darling. Over the last 10 years, 15 years, $13 billion has been spent on trying to transform the institutional governance arrangement for water. And they've implemented this Murray-Darling Basin plan and water market that's been held up as one of the gold standards when it comes to what we should do with these market designs. But as a result of insufficient in-stream flow and too little oxygen in the system, we've seen all of these fish coming to the surface and dying in the last few days. So the system, even though we're spending all this money on it, is not delivering the outcomes that we want. Obviously, parts of California are severely overdrafted. And so in California, 2014, they implemented the Groundwater Management Act to try and address this. And they're in the implementation phases at the moment, but still they don't really know how to do it. And how do you shift a system from being over-allocated to one that's supporting a sustainable threshold when it comes to water? And even here where I'm from in New Zealand, where everybody thinks of it as this clean, green utopia, we've got significant issues when it comes to both water quality and water quantity. We've got several catchments, not just several, but significant swathes of the country that are over-allocated. We don't have any water markets operating in New Zealand, so it's under a regulatory standard framework, but we're still not addressing these problems. So the question then becomes, what do we do? Well, some people argue that we should grant nature or the environment legal rights. And so this idea behind granting nature legal rights is that nature or a natural feature is granted legal rights, which means it can sue and be sued, it can enter contracts, and it can hold property. Often in these cases, guardians are appointed to speak on its behalf because obviously a river can't speak for itself. And in an ideal situation, there are supporting institutional frameworks to give these rights force and effect, and also funding provided. And one of the most well-known cases that sort of put this on the international scene was in 2017 when the Wanganui River in New Zealand was granted legal rights. And all of a sudden, people thought of this as a really innovative and revolutionary solution to environmental problems. And since then, or even before then, we've started to see a massive increase in the number of these cases occurring around the world. When it comes to legal personhood or rights of nature, there are now 325 cases globally. So it's not something that's occurring in one or two instances. It's occurring all over the world for nature as a whole and also for individual features. You can see in the last 15 years, it's really started to take off. Of those 325 cases, 55 cases specifically related to freshwater. So there is a significant number of instances where this is occurring, but we still don't know what that means in practice and how these are functioning and whether they are potentially having any impacts on social or environmental outcomes. And so when we look at this through a bit of an Austrian lens, there are two main pathways that these cases are being operationalized. One is through a judicial pathway, and of those 325 cases, 111 examples have arisen out of court cases. And then the remainder are in statutory law or international law. For those that are coming through the legislature, they're occurring at all different levels of the institutional arrangements. So some of those changes are happening at the constitutional level, some are happening at the policy level or the collective choice level, and then others are happening down on the ground at the operational level. But although we're getting all of this variation, and although this sounds new and exciting, what in our discussions we've started talking about is that rather than this being a revolution, as it's being framed often in the discourse and in the media, it's more of an evolutionary response to the changing patterns of environmental flow regulation and also in law. Although declaring nature to be a legal person seems outlandish, it is not unusual in law to use this concept of legal fictions or legal persons as they apply to non-human entities. And so corporations or states or municipalities, trusts, ships, deities, all kinds of things have had these concepts of legal persons applied to them as a way of managing and looking after them. And we also use this trustee relationship in all kinds of as a legal tool to look after all sorts of things. For instance, how does a human baby articulate and defend its preferences and rights? Well, obviously parents or a legal guardian is appointed to speak on their behalf. And the trusteeship of natural resources already exists to some extent under the public trust doctrine. So this idea of legal personhood is extending that thought and applying it to a new problem. The problem is, though, it's remaining unclear how these institutional arrangements work in practice, what the impacts on social ecological outcomes could be, and can it actually deliver any marginal improvements? Why would we even do this beyond status or assigning rights? It's not entirely clear. It's also not clear how the concept could work with existing property rights. So often it's used at the moment as a substitute rather than a complement to existing regimes, but it's could we use it in partnership in a more polycentric way with existing governance mechanisms? And finally, how would this idea of legal personhood work within a polycentric system? And so as we grappled with these questions, we've developed some formative research questions to try and get more specific research and also tackle a bit of a policy problem and also meet the needs of my grant. So firstly, the question of how could legal personhood be integrated with a water market? So we have this idea of water markets operating where people can trade and exchange their rights over use. What happens if that river owns itself? If the river owns itself, how can you trade and exchange those rights? And are these two arrangements compatible or not? The second question is, how would legal personhood even affect in-stream flow provisions in a water market? So if we were to do this, is it actually going to make any tangible difference, or are we just shifting forum shopping essentially as we try and move from one arrangement to the other? And our motivation ties back to those broader research questions. Could legal personhood be an alternative mechanism to increase the provision of in-stream flow in a polycentric system? So could we be addressing some of those public good questions, those in-stream flow questions, with this idea of legal personhood? And so we have some tentative early answers. From a normative perspective, people might say no. This idea of having an ecocentric concept where you're granting rivers legal rights, the river becomes a subject of rights rather than object, and then you're trying to integrate this with a price mechanism. Those two concepts fundamentally might be perceived as mutually incompatible. But from a theoretical or positive perspective, there's no reason that you couldn't really do this. People sell their labor and assets all the time. If you're stating this river owns itself, then essentially in terms of water, it's just selling its assets and allowing people to trade and exchange those assets. And so from a theoretical perspective, perhaps this is possible. From a practical perspective, potentially. One thing that's really picked up on in the literature is the fact that in every single rights of nature or legal personhood case as it relates to water or freshwater, water itself has been excluded from the judicial ruling or the legislation. So what they've tried to do is say, hey, we've got this all-encompassing idea where we're protecting nature and we're recognizing its intrinsic values and all of that. But when it comes to practical implementation, we're removing water. And so basically it's a way to keep existing property rights arrangements in place and to minimize disruption through the transition. But from a practical perspective, it really raises questions about what the impacts of this will even be if you're excluding water from decision-making. But if we're thinking about this in terms of integration, the fact that all of these concepts are already excluding water might create implementation pathways for integration. There are also deeper institutional questions, and this is what we're grappling with at the moment, and it'd be really what we're trying to understand is whether granting legal rights to a river is just a mode of forum selection. Okay? So we're changing who has decision-making authority over a particular domain. And we're basically transferring responsibility in some ways from the legislature and elected officials to these people that we're appointing as guardians. And so are we just shifting decision-making responsibility away from the legislature to the judiciary, who will ultimately make decisions over whose rights matter in this instance? And then the big questions of, would legal personhood actually be an improvement on anything? Are state water quality laws doing enough already? What additional benefits could we get from granting legal rights to rivers or nature engineering? And so in a US context, how much would it add to the public trust doctrine of state law protections of in-stream flows? And there are huge, well, not huge, but there are further emerging questions that I think will keep on coming out as we answer and explore this. And it'd be really nice to hear some of your thoughts here today as well. So where are we going from here? This first paper is probably looking at the evolution of in-stream flow provisions to try and understand whether there would be a role for legal personhood. Part of the reason for doing this is that first paper is twofold. One is to meet the conditions of the grant, and the second one is to do a tangible project that allows us to test some of the bigger questions that we're hoping to explore in Article 2, which is some skepticism around the problems of this idea of resource self-determination or resource personhood. And then if we still have motivation, we might get onto a third one, but we'll see. But as I said, hopefully I can turn this back to you and we can have a bit of discussion about what your thoughts might be. And if people have any further ideas or feedback beyond this session, I'm really happy to take things over email. So thank you.
Hey, I will be in the queue. You want to start, Mike?
Yeah, sure. Julia, it's great to see you present this stuff again. It's been a while since, and you've developed different ways that it's getting more interesting, actually. It was kind of a shock initially to think of this idea, but you're sort of trying to deal with the practical implications here. And I was struck by something in the paper you sent, or the article you sent around as part of it or included, and your comment just about the water, that the water itself is not included in any of these. And you also talked in the paper about fish are not included in most cases. Okay, so it sort of gets me thinking that this wasn't really an effort to give these natural resource systems or whatever, rivers or whatever you're dealing with, rights that would be useful in a market or in a legal sort of framework. It really was a means to achieve some other goal. And I remember your earlier presentations, one of the major goals in the New Zealand case was to protect Indigenous people's rights. Okay, and this was something that was particularly important to them. And it was, and this idea of guardianship. So I mean, my guess is that some of the people that were thinking of doing that in New Zealand were thinking of it more as Indigenous rights than as an environmental resource. I suspect in a lot of the other ones, it really was just an environmental protection with the assumption that this has got to be better than having markets or regulation or something like that. And so what it sounds to me like is that no one's really taken the idea seriously enough. And it sounds like what you guys are trying to do is to say, no, this is a form of property. Okay. And you know, whatever's within the water or the riverbed or some aspects of the catchment are treated as being owned by this river or whatever entity you're doing, in the same way that everything on my plot of land that we own is you know, my responsibility with limitations. Okay, I mean, you know, I can't go in and start ripping up pipes and I can't protect people from walking through it unless I put up a fence or something. So it seems to me that the only way this could become real would be to start to think about how this would interact with markets or integrate with a regulatory system. So I think what you guys are really doing is taking this whole point in a very important new direction and taking it seriously as a form of property. And I know Dan knows a lot about property. I sat through a seminar at one point and I love the slides, but other than that, I just didn't really know what was going on. But it's just fascinating. And I think, have you thought about framing this a little more audaciously, if you will, as saying, yeah, here's an interesting idea that was used for environmental protection. We don't know if it really works. It was used for indigenous people's protection. Well, we're not really sure it works for that either. But you know, if you're going to take this idea seriously, this is what you got to do. And if you don't have any cases of that, it's going to be kind of hard to demonstrate that. But I think for the theoretical arguments, this would really be a good mechanism to do it, and to say that, you know, if we really focus on this as part of what are the implications of seriously treating this as an entity that's owning property, and then all the ramifications in that. And I think that would be a very interesting project. And then later on, once you convince people to take it seriously and implement this, then you can do the empirical analysis, you know, after you've got some cases sort of thought of. But that's the way I would frame this, is that, you know, get in their face and say, look, this has been an idea. It's increasingly being used. We don't know if it's working, but we do think it really hasn't been tried seriously.
Yeah, well, I think that's really useful. I think trying to understand how to couch this in a convincing way that demonstrates that it does, it is worth pursuing as part of the goal of this. There's been a lot of normative discussion in the literature about why this is a really nice idea, and why it should be really good, and we should really give equal rights to nature because it just sounds good. But there's been less serious analysis, particularly from an institutional perspective, to try and understand what it means in practice. The difficulty is the empirics aren't there, but they're clearly emerging. And one of the goals, if we get there, in paper 3, is to do a more in-depth analysis. But even within this paper, if we can do a conceptual application of some kind, and one of the areas that we're thinking about is the Deschutes in Oregon, because they've had a evolutionary process in how they've protected their in-stream flow. And then we could say, hypothetically, if they took it this next step, what extra marginal benefits might be delivered based on what we understand from theory. That could be way that we're pursuing some.
Shannon, and then Joyce.
I echo Mike's sentiments, that I think it's almost like the development of a regulatory framework, which is really cool and exciting to see. Assuming that there's cases and this exists, I also think a really interesting application would be looking at how that works within interstate, within like a federalistic system. Looking at how interstate commerce would maybe relate to personhood, and if that would even solve it, because that'd be interesting. And then I would also encourage you to kind of think about how the mechanisms of who's getting assigned that guardianship, what the best economic, social, and environmental situation would maybe, just because I think that is like the crucial question here of who's the decision-making, who has the decision-making power. And then this is just a question. Is there a provision that the money, like hypothetically, if the money from some economic trade of a river, like how would that money be used?
Yeah, so to answer that last question, we've talked about this briefly. One of the ways that I thought that it could feasibly, any revenue that's raised through the process could be argued that it goes back into things like riparian planting or improving environmental outcomes in that way. And you can see some sort of revenue cycling occurring that's used to enhance the health and well-being of the river overall. So, but those other points are really useful. I think with the transboundary issues, there are some cases globally, and the one that I'm thinking of at the moment is in 2017, the Ganges River and Yamuna rivers were granted legal rights, and that's still by the Uttarakhand High Court, and that's still stayed at the moment. because it was deemed that the court overstepped its jurisdictional boundaries. And so as soon as you get into transboundary issues, there are all kinds of challenges that arise. And I definitely think it's an interesting question, but I just don't think we're anywhere near understanding what would be the transboundary implications of this.
If I can chime in on this, you also mentioned the administrative structure, right? Who's making the decisions. New Zealand has dealt with this issue more seriously than most of the other cases, right? So there are two decision makers, one representing the Crown, one representing the Maori, and they have to reach consensus decisions. Beneath them is a 17-member panel.
So there's an advisory group that advises the guardians, and then there's another
Subgroups of advisory bodies here.
So it's like a pseudo government organization, or it is a government organization.
Yeah, I think you can think of it as a sort of a quango.
Oh,
I'll
sorry.
just make just one, but that's the fact that you're having these community. I sort of made an argument that in another paper, that the institutional framework that they've developed to sit underneath the legal rights in the Wanganui River case basically is a way of shifting decision-making authority back to the operational level of decision-making, or a community-based structure, but again, it's about shifting that decision-making authority more, and then how they give those arrangements force and effect in time.
Yeah, that'd be super interesting in the context of the United States, because it was so high up. Making right now. Thank you.
So I'm curious if you know the work of Jane Gleason White and the whole integrated reporting. There's such a tie-in here with 6 Capitals, which is her book. And it's, you know, how the accountants save the earth. And basically, this is the King reports in South Africa, where they've done there's the four King reports. This goes back to the 70s or maybe even the late 60s on corporate governance. And one of the capitals is natural capital. There's human capital and all of that. Jane writes a really great book on like the whole problem, but it seems to me like you have another lever here. Yes, the legal person thing is part of it, but how do you do the accounting? And that's what the integrated reporting does. And it's I think it would be really nice to show there's more to this than just saying a river is a legal person. There's corporate governance, good corporate governance policies that have been worked on for many years that could come into it. And then you have sort of a bigger story about how this is more possible than just like, we're just going to go to the courts and fight it out on a jurisdiction by jurisdiction basis. Because if you have a transnational corporation who's willing to do the accounting for it, then you have that helps the policy stuff. It's just an interesting thing that I followed this for years because I know Jane, and it's just fascinating to me that it was only coming from accounting, but now if it's coming from legal also, it'd be very interesting.
Thank you for that. I don't know that. Well, like obviously the Capitals, but I don't know her work, so I'll follow up.
And it also comes to some extent from the mid-20th century economics literature on definitions of real economic growth from Sir John Hicks.
Have Diego, then you, and then Scott.
Well, thank you so much for this presentation. It's very interesting to see all of that in Colombia. The Escazú treaty was passed through after so many things and reach out questions about how they are really doing because of the goods for nature or just for political purposes, and we both. For that is also part of this discussion. But I was thinking in something, sorry, my ideas are like probably sharing, you can something, and something that you say about the water and why this is not part of these legal rights. And I was thinking into the concept of legal person and how this is built, like, correct me or all of you that really knows about that, but usually the person that, or the corporation, there is always something that takes care of that, either the parents or the person that builds the corporation, or if it's a foundation, the boards, whatever. In terms of the water, probably one of the cases is who is the real owner of water. In Colombia, the Paramos, for instance, and all of these kind of continental communication about who the real making of the water is not even a country, not even a region. Therefore, not sure your thoughts about how this is part probably of the problems of making the legal person rights or those kind of things.
So, sorry, let me just make sure I followed. So what you're saying is that it's usually the state that owns.
Yeah, if I understood correctly, giving the legal person rights to a river at this moment as has been done is like either the government of the country is the one that knows at the end, like the ones that are creating the rights. However, in terms of water, sometimes the water doesn't born, that is not created only at the country level. Usually are a huge ecosystems.
Okay.
And that's probably part of the reasons. I don't know what are.
So, yes. So is your question the fact that water itself stretches beyond beyond jurisdictional political boundaries?
Yeah, that's sorry.
And so that the natural hydrological cycle means that a political system, lines drawn on a map are artificial.
Yeah.
And so you're saying as part of the motivation for this to address the fact that you're having potentially extension beyond a political. I don't really. So in the Himalayas case that occurred in India, yes, I think it's again stretched beyond. It was saying that the Himalayas affected everything. It had impacts for countries beyond India because it supplies water to millions or billions of people. And this was a way to ensure that there were broader level protections over something like the Himalayas. But when it comes to fresh water, specifically, fresh water, better or worse, is often thought about as a local problem, whereas climate change is thought of as a global problem. Fresh water can often be seen as a local problem. And some people might disagree with that conceptualization. So I actually don't think people have implemented this idea of rights of nature to address the broader global challenges associated with the movement of water through a hydrological system. It's been more for the reasons that Mike touched on, either cultural reasons, such as New Zealand or Colombia. They wanted to recognise the rights of the Indigenous people or the local community that were not getting a voice. In other cases, it's been for social reasons, the fact that just a local group, not necessarily Indigenous, needed some form of protection or recognition, and then obviously environmental reasons at a local level as opposed to an international. I don't know if that actually reminds.
Yeah.
Yeah, so I'm no legal scholar, obviously, and it seems that it's often framed around the idea of granting new rights, which I think is right. But I think in my mind, another important contribution of this is like a simplification of the judicial and enforcement proceedings of these kinds of things. So like, especially in a US context, like something like this could potentially serve to greatly simplify rules around standing and thus make it a lot easier to actually enforce the policies that exist at a federal level, which are of course very unevenly enforced. So to me, that's like the huge benefit of this, more so honestly than trying to codify whatever rights they are, because as you say, that varies greatly depending on the location, how much is actually allocated to to the body in particular.
Yeah, and I'm going to leave that to Dan. My short comment is that I think that has been a critical argument for people who have supported this idea, is that it gives nature standing in court and gives them a voice where otherwise they wouldn't have had it. People who have been critical of the idea have argued that standing law is sufficient as it is, and we have sufficient legal protections in place that mean that this is not a necessary advancement. So you've got two really clear schools of thought around this, and Dan, you might want to add.
Yeah, in the US case, first of all, standing law is just a mess. Right. The current Supreme Court standard is not the standard that actually gets enforced in the lower courts, which is the Scalia standard that the Supreme Court eventually overturned. But the idea that the primary purpose of this would be for standing is quite right. This goes to Fritz Stone's original idea in 1972 in the book "Should Trees Have Standing?" Right, that's the idea came with. Let's give them standing by declaring that they own them themselves. Give them legal personhood. So I think that's quite right. But there's very strong reason to believe that U.S. federal courts anyway would be highly resistant to expanding standing in that way. State courts depends what.
Scott?
Yeah, well, first off, this was terrific, Julia. So nice job. And just take these in the spirit of brainstorming, because I've kind of done a little bit of reading and writing around this topic loosely, but not squarely on this in the direction you're coming from. But in my mind, because I know this is still in an early phase, but maybe you could begin with a little bit of, so the end goal is clearly more effectual water governance with a larger role for stakeholders, surrounding communities, more sustainable use. So I'm wondering if you could talk a little bit about the benefits and drawbacks of other approaches that are out there, like the human rights of water comes to mind. So what does international human rights law do here? What doesn't it do? What about the extension of human rights to animals living in these waterways? Because there's a rich literature around that, which in some ways makes it more complicated and in some ways less. And I just did a quick search and I found this recent piece called Rights of Nature, Rights of Animals by Kristen Stiltz at Harvard Law. You probably know it already, Dan, but I'll send it to you because it looks like that could be on point if you're interested in that arena. And then the other ones were like, all right, what about ecosystem-based management? That's a bit more plain international environmental law, but could that be more useful here? And the point about how you split the proceeds, like the common heritage debates and the International Seabed Authority come a little bit to mind. Could there be any multi-stakeholder process like that set up domestically where the resources would be split with X percentage going to sustainable use down the road? And then the last thing that came to mind was, what about the discount rate? And this is more in your world, Gustavo, but it's like, I remember reading the Ministry of the Future not too long ago. It's that Cli-Fi, the climate science fiction book, but he does so much with discount rates as being an effectual tool here for more carbon and climate governance. But what about water, right? So, I mean, could that be another way to come at this problem? So, you can't boil the ocean, you can't do all this, but I'm wondering, like upfront, could you maybe tease out some of these benefits and drawbacks and lay it a bit more, clearly, all right, this is how property and personhood really could fill in some of these gaps that these other, levers just can't for political or cultural or legal reasons.
That's helpful. Thanks, Scott.
Yeah.
I don't have any response, but.
No, it's okay.
Yeah.
It's okay. No, quite all right.
To think how self-ownership, obviously with water markets, discounting is an obvious issue.
Yep.
With self-ownership in the mix, I'm not sure how it plays out. I mean, how paternalistic do you want to be in setting discount rates as opposed to sort of taking them as you see them, as you see individuals discounting? And then what way of determining the discount rate do you use? Do you use the opportunity cost of capital, shadow price, Ramsey discounting? So Europe's been dealing with this issue more effectively, certainly than Office of Management and Budget in the US, including introducing hyperbolic discounting into the mix. But I don't immediately see how that fits with the personhood designation. It's an interesting question.
Oh, yeah.
So I will jump before so into the queue, and then we'll see. I see some comments in the chat, so then maybe we can go. So maybe a little bit devil's advocate here and argue against this. Okay, so I believe that modern societies definitely need competent bureaucracies with good incentives. Okay. So essentially what we are seeing with this type of problems is like the standard bureaucracies that we created to deal with these problems, they are failing. So it's like the political system is not dealing properly. The bureaucracies in charge of implementing, they are not working well. And then we are trying to somehow evade the problem rather than facing the problem, okay? So what this is generating from my perspective, so what is the political economy dynamic of all this? You're throwing the problem to the judiciary. Yeah? So essentially, my prediction of that is you end up screwing the judiciary rather than solving the problem. That's the most likely scenario. So I think that at some point, we really need to think there is no escape of having competent bureaucracies with proper incentives. And then if we give like legal rights to a piece of an environment, but then essentially you are going to create managers that more or less have the same incentives as actual bureaucracies, we are going to end up with more or less the same problem that we are facing with regulation in the financial system, that every time that we have a crisis, we create new bureaucracies with the same incentives as the previous bureaucracies. So the bureaucrats on charge, they will get exactly same payoff if they properly regulate banking or not, if they are in the pocket of the financial system or not. So essentially, we need to come up and think more carefully about the incentives of those managing, okay? So again, from my perspective, it's if this is helping in the process of creating a real good bureaucracy, and I'm not much worried about competency. I think most developed countries have relatively competent bureaucracies right now. The problems are incentives. So essentially, it's how are we monitoring? So what are the incentives of anybody running this? That after you're running this for 4 years, the quality of the water, it's good or bad. How are we going to establish incentives? I think there is no escape rather than saying your payoff somehow will be different if we find after 4 years that the quality of the quality of the water in this river is crappy or it's good. So essentially, and giving rights to the river doesn't solve that problem. Okay, in some sense, it's obscuring the issue more. Again, I'm not fully convinced, but I adopted the opposite position to help you. Maybe that, from my perspective, will be the best possible argument against this. If you fight against this and you convince me, you convince the readers that this is the way I'm thinking is wrong, that maybe you can build a better argument. No?
I don't think any of us are convinced you're wrong at this point. But there are a couple of interesting things to note about, like all political economy, the context in which this is arising, positive political economy perspective. In New Zealand, there was long-running conflicts between the Crown and the Wiki, the tribes, who have fundamentally different conceptions of watershed. And finally, they got to a treaty arrangement, and this legislation, right, was in compliance with the treaty obligations. Is that correct?
Part of it, yeah.
And so now you have these two guardians who have to make decisions by consensus, who have or represent different understandings of the river, very different discount rates.
Sure.
Okay.
And so the hopeful argument would be, because they are representing different conceptions, different interests, different kinds of values, that if and when they can come to consensus, the hope is there will be superior management of the water. Now, another part of the political economy of this, which I think I started talking to Julia about when we first started talking about this last time she was here, was it seemed to me like the Crown was punting the issue to the judiciary because they were tired of dealing with it themselves. But that also, I think, underestimates the extent to which the government was really trying to find a cooperative solution to the problems with the indigenous people.
But another way of doing the same thing without creating all these legal complexities, like what you're saying is that you want to give property rights over this to somebody that cannot use it and cannot sell those rights to somebody that can use it. So it's not used and it's preserved for the future generations. So essentially, it's something like that. It's
That solves the problem, but of course, it's completely implausible.
okay. Well, it's like can we generate something like that? So it's essentially.
So I think, I don't know, so one of the questions that I think I was even asked here last time, was, because they've done it for some land-based areas as well. What's the difference between doing this to creating a national park? And what I think is, this doesn't necessarily touch on what we're talking about today, but I think what is consistently missed and hasn't been explored yet in the literature is the role of underlying values in this process. People often look at the formal rules and they argue, they say, right, let's just create these legal rights and then shift. This is a third pathway, might be punting responsibility in some cases from the legislature to the judiciary and so on. But in the case of the Wanganui River, for instance, it was the fact that they had the current property rights arrangement where the Crown owns the river is not okay to the local Māori. And the Crown had said it's not okay for the local Māori people to own the river either. So we have to create a third pathway. Meanwhile, the Māori people also said we want to have our worldview articulated in law. And this is the part that's often missing from the broader discourse in the literature, is the fact that what they are trying to do in that famous case, which blew up in the international media, is they were trying to articulate the Māori worldview in law in a practical way.
And establish a condominium of the Crown and the Maori people.
Which is what you did effectively.
We need to create a new legal.
No. What you're missing is the fact that in Maori law, in their worldview, there is no distinction between place and people. So people and place are one and the same. And people don't have dominion over resources or the environment. And so what they were trying to do, using a Western legal within legal tools is create that in law. And so they were saying, right, we're going to recognize this river as a person to give it its own status. And then we are going to develop an institutional framework to uphold those rights. And so it's the fact that it was done on a model of a worldview that's separate from a Western.
As an analyst, in that case, I would say this is a common run by the Maori people underground, but because calling it like that, it's insulting for one of the parties. We are creating a new label, but that's it. This is a standard common.
And this is it. And so other people, I don't know if the outcomes will be any different to what we would observe in any other institutional arrangement or governance setting. But there's just all this ho-hum around giving things legal rights, but it's not clear that it will deliver any outcomes that are fundamentally different to a national park or something.
And
The agreement is
It
also,
changes the
also
preferences.
the political economy goes way beyond the river, right? So this also, it's, first of all, it's a compromise between both worldviews. But it also presents an opportunity to improve levels of trust
Okay.
between, right, between the colonists, settlers, and the Aboriginal inhabitants, which I think we also shouldn't be overlooked. And we haven't really talked about that yet. Okay. Julie, I mean.
Yes, sorry.
Has a question.
Thank you. So as I was coming in on this conversation, one of my thoughts was that, giving the tree a personhood or the river personhood, it's almost like the sense of animism, like a religious animism. Is that then a present part of the Maori tribe? Or sorry, it's been a long time since I've thought about animism. The idea that you have, the idea that a tree has like a personality too, or the river has a personality. Is that part of the Maori culture?
Yeah, absolutely. So recognizing the fact that, so the first piece in the legislation recognizes Te Awa Tupua, and this is in the Wanganui case, recognizes Te Awa Tupua as a living person. Oh, sorry, as the complete whole, including all the physical and medical, including all the physical and metaphysical parts. Oh my goodness, that's such a butcher. But essentially, it's recognizing it as a living being, which touches on what we're saying.
So we are running out of time, but I think they are. Scott, are you logging? So can you see? Can you see? Okay. Sorry, I didn't do that.
Oh, sorry, Bernie. Save the chat, Julia.
Okay.
We just won't log out
While
immediately.
we're going through this, a point on Janie's point about animism. It's also an interesting issue worth exploring because, of course, the traditional religion of Japan, Shinto, is an animist religion. And then the question becomes, does environmental protection work any better there?
So maybe if you read that comment, sorry, I should have logged on to the chat today. I didn't do it, sorry.
Yeah, it's just barely being nice. Can we turn off the slideshow view?
Such a-
Angie, sorry.
Sorry, Angie.
So I'm not sure if there was a question there.
If you click stop share, it should work, right?
Yeah. Well, thank you.
Should I say this? 400. So can I research program got something?
It seems like it was a comment, not a question. So do you want to wrap up in 30 seconds.
Well, thank you for the opportunity to speak today. I've got some really interesting comments and extra things to think about. We still don't really know where it's going, but if anybody has any extra comments or thoughts.
Are you less or more confused now?
But other people have also raised things that are worth exploring, and that makes it a worthwhile research puzzle. It's better to have a conversation about this and feedback and ideas coming in from different perspectives than just have silence and everything.
Yes, awesome. Thank you so much. You are always,
Indeed. Let's just see really quick.
I think we have the regular colloquium and research series, so please check.
Yeah, that's great. I think we're good. We have Daniel DeCaro on Monday. And the water governance group.